हाय दोस्तों, ब्रास ग्रुप के चैनल में आप सभी का स्वागत है। ब्रास ग्रुप आपके लिए लाया एक नया लेसन। आशा करता हूँ आप लोगों को पसंद आएगा। धन्यवाद।
Last week, what we found is you wanted some time reserved for discussing it and maybe commenting on the paper that we are reading in the class. So we have reserved today's class for that specific purpose. So please let us know if you have any questions or comments or queries. Yes, would anyone like to respond to our discussions which we had this day?
I think any questions that yes,
ma'am, I went back and read William Starr's article, and in one of the cases he said that Hart rejects necessary correction of law and morality because, firstly, because of the issue of practicality, that we can't have a narrow approach, and secondly, he criticizes this connection based on morality itself, that if the wicked justify the laws on the premise that since it's a law and law must necessarily follow morality, then that will be the definitive answer to the question of morality. So that is a point I'm a little uncertain on. So if we could talk about that.
Yes, ma'am, I have the same question.
Could you please ask the question again? That Hart has rejected the first place that that law and morality are separate things. However, going forward, Hart says that morality does form. It might not be related to law, but it is definitely something that gets into law. I mean. What did you ask? Did I understand you correctly?
Ma'am, my question was that Hart rejects the naturalist point of view that law must necessarily follow morality based on his own notion of morality. He uses a sort of morality critique, to use William Starr's words, that if a law is seen to be always as pursuant to morality, then whatever law that comes about will be justified on the grounds that it is moral, and so you cannot ask any questions or raise any doubts about the law.
Yeah, so this is the natural law point of view, that any law which is supposed to be immoral or which seems immoral will be rejected per se. This is the naturalist point of view. So then what is your question?
Yes, ma'am. Yes, ma'am. This is the other side of the argument. While naturalists say that if anything is immoral, it will be rejected. But once they say that this law is moral, and there will be no further discussion on that, so it will stop being evaluated. That is what Hart says. So can we talk about that part?
No. See, what Hart is saying is he is rejecting the positive natural law point of view. He says that if for a natural law philosopher or natural law legal person, if this law, whatever the law is being framed, that law necessarily has to be based on morality. If it is found that that law is contravening morality, morality means which morality? Morality of the people, or maybe at large the society which is continuing. Under such circumstances, if this law is found to is contravening the morality, then that law will be completely rejected by a naturalist. Now, Hart says that this understanding of the natural law is something that we cannot import. And Hart is saying that this cannot be the ground. I mean, a law to be valid or invalid, you need not see that whether it is moral or immoral. Because if you do that, then there are basic issues. For example, let's say for an Indian society, we do not consider that marital rape is a crime. In the sense that it is fine. A husband, when you are getting married to a woman, it's the legal, social, moral, cultural right of the husband to, indulge into any form of physical relation with his wife, with or without her consent. Now, if this is the morality, and suppose there is a law, or suppose there is no law which states that this is wrong or something, then based on morality, this will be accepted. And if a law is made on this ground, the natural law theorists will probably say that this is a wrong law, because you cannot frame a law which goes against my morality. And my morality is that with marriage, it gives me uncontrolled access to the body of my wife. Okay, now this is what the positivist say. Natural law says. Hart says this has major issues. And Hart says law cannot be conceived like this. You cannot say that this law, whether or not it is moral or immoral, and it is being rejected based on that ground, is wrong. So Hart's understanding of law is that while the natural law theorists will per se reject this law stating that this is immoral, but Hart says this law should not do that. Hart is not completely speaking about this command theory also, like Austin and Bentham did. So Hart says that not all law that is being made by the sovereign is going to be directly recognized, because it has to, going forward, it has to, survive the test of morality also. But at the first instance, when the law is being made, we don't reject it per se because it is immoral. Yes, going forward, when questions will come up, when the law will be scrutinized, that is, he's talking about the judicial system then. So when this law will be scrutinized at a later on period, then all alternatives which are available will be scrutinized, will be critically analyzed, and the judge who is going to, deliberate on the matter will be taking into consideration all moralities. And here also Hart says that this is not that simple a process. So Hart also says that while the judge is doing that, the judge will also have certain moral perspectives only to do it. And therefore, maybe not one morality, but the judge will have to, analyze more than one morality, numerous moralities. And this outcome that is going to come out, according to Hart, he says this outcome might not be right. So suppose the judge says this is a moral law, or the rights, this is a legally valid law, or it might say that it's a null and void law. Whatever the judge says. Hart again says that, well, this entire functionality, this entire process will involve morality, of which the outcome may be right, may be wrong. But at least the legal society would know that this outcome is only after proper deliberation of all available alternatives. But while doing that, morality will come. The perspective of morality will definitely be taken. But in the first instance, without even analyzing or critically looking into the law, you do not reject it saying that it is immoral, like the natural law did. That's something Hart is saying no. So Hart is, somewhere in midpoint. So positive, it would say that command of the sovereign, it is law, end of story there. Immoral, I don't care. A natural law philosopher would say law, immoral, per se, it is invalidated. But Hart says we don't do that. We accept the law. This law need not be, while the law is being framed, it need not be, imbibing within itself the moral perspective. But yes, going forward, morality is bound to come in, because in the positive law theory, not overall, the command theory of Austin and Bentham, if we see, there you are accepting a law, and this law could be completely devoid of morality. And still it is law. So if the parliament, legislates, let's say, examples of kings at that point of time when, there were certain examples where they would say that, any blue-eyed baby boy should be killed. Now, because it is coming from the sovereign, and Austin or Bentham would say that this is law because this is command of the sovereign, because they do not care whether it is moral or immoral. So, coming from here and the natural law theory, Hart imbibes both of them, comes in a middle stand, and says that the first instance we don't reject the law, but then going forward, of course, we have to scrutinize, and that is where morality enters into law. So, therefore, you see everywhere, again and again, Hart continues to say, law and morality are, they are very close to each other. They might not be related, but they are always close to each other, and this is something Hart never rejected. Could I clear your doubt, Vikramaditya and Kirti?
Yes, ma'am. So from whatever I understood was, Hart feels that if there is no necessary connection between law and morality, but there is a subsequent influence, interrelation between the two. So in that way, all diverse moral claims are entertained, even though everyone might not be satisfied. So that impartiality clause is satisfied.
At the first place, law and when law is being framed, morality might not be a part of it. Period. Okay, this is what Hart says. Yes, your second portion, that yes, consequently, morality is to be, imbibed into, is used to scrutinize the law and validate the law, which is true. And then going forward, whatever the outcome is, for example, if you take Srinamya case, so the outcome was that the Supreme Court said that women would be allowed to enter into the temple. Now, whether it is right or wrong, we don't know. And Hart says that it is not possible to, claim that it is a right law or not law, because morality also varies. There are various types of morality, and this is the greatest challenge of, being influenced with morality. So under such circumstances, at least we know one thing, that this judgment that comes out is the outcome of proper deliberation and taking into consideration all available alternatives. So this is something that we can be rest assured. Whether that morality is the majority of morality, or that morality is good, bad, not good, we don't know about that, because morality itself is a very wide concept and it differs from person to person, time to time, society to society, etc.
Okay, ma'am. Thank you.
All right.
I just had to. Okay, Anjali, let me just add to what Ruchita was saying in response to Vikramaditya's question, then we'll pick up your question. You need to understand that so what Ruchita said, I'm just trying to extend on what she said, that there is a concept called legal validity, right? And that is something that we have studied when we are studying Hart. Now, Hart's premise is that legal validity and morality are two different things. That is something that we have to understand. In order for a law to be, or primary rules of obligations to be legally valid, or secondary rules to be legally valid, it need not necessarily conform to the concept of morality. Now, as Ruchita said, we are not right now bothered with what that morality is, but just not necessarily conform to the idea of morality. And here I will point out one argument that was given by Ruchita yesterday, that laws may be morally relevant but not morally conclusive. Now, in that regard, I will just give an example. I'll put an example before you, and maybe that will help you apply Hart's theory to that example. There is a very famous case called Srinamya Case, and some of you might have heard about it. Now, this case is Ruchita, can you just switch off your mic for a minute?
Yeah, sure. I'm sorry.
So sorry. Yes. So this case is about a woman who was in abject poverty, and out of desperation, what she did was she poisoned her 5 children, and then she herself jumped in the well. Now, what happened was that her 5 children died, but she survived, and she was tried for culpable homicide amounting to murder. Now, the question now before you is therefore whether this woman must be convicted under Section 300 of IPC or not. Now, what the judge who said was, and the response of judge or the person writing the judgment comes very close to what Hart understands by law and morality. Now, what was observed in the judgment was that this woman who died took this extreme step because we as society had failed her, because the society could not take care of her basic needs of food, shelter, and clothing. And that's why out of abject poverty and desperation, she took this extreme step of killing her children and herself drowning in the well. But despite that, because the law says that if someone knowingly causes any bodily injury to the other person in order to cause the death of that person, then that particular person would be convicted under Section 300. So I have to convict this woman under Section 300. But the judgment also recognized, or at least recognized, the fact that perhaps this specific judgment may not be a moral judgment, but the law forces us, or the law says that we need to convict this woman, right? Now, what we see therefore here is that while morality is legally relevant, but law is morally relevant, but law is not morally conclusive. We see a very much divergence between, at least from one perspective, there is a divergence between law and morality, because we had as a society failed women, and morally or ethically, it would have been better not to convict her for killing her 5 children, because she did it as an act of utter desperation. But because the law or Section 300 so says, the judge had to convict her. Now, And this goes into what Ruchita is saying, that what Hart says, and or Ruchita just said, that Hart lies somewhere between extreme positivism and extreme natural law philosophers, wherein Hart does not say that or does not discredit the influence of moral on law. And as was said by her, that morality comes into defining law at various points. So there are different points of influence on law of morality. But that does not necessarily mean that law always has to be moral. Okay, that is what you need to understand with respect to Hart. Hart does not deny the role of morality in law. Nowhere does he deny it. He accepts the role of morality in law. Unlike extreme positivist attitudes, wherein law and morality are completely two different spheres. Hart recognizes the role of morality in law, but does not recognize the role of morality as giving legal validity to the law. That morality will conclusively determine whether something is a law or not. There can be situations, and rather there are situations when law and morality differ. So while Hart recognizes the influence of morality on law, Hart also says and argues that law and morality are not one and the same. But when Hart says that law and morality are not one and the same, he is not taking the position of the positivist who lie on the extreme end of the spectrum when they argue that law and morality are different. Rather, he concedes to the fact that morality influences the shaping, formulation, and perhaps the change and modification of law. So perhaps in Srinamya Case, there may have been, subsequent to this judgment, there is a possibility that the law, because of this judgment, is amended. And in order to address that specific situation, it can be said that if out of utter desperation someone indulges into an act under Article 300, Section 300 of IPC, it may not be culpable homicide amounting to murder, it may just be culpable homicide, or maybe it is considered to be a valid defense. So subsequently law may be modified, and why will the law be modified? Because morality is influencing the formulation of law. So that is trying to keep that in mind. So as Ruchita said, that Hart lies somewhere in between. He is not on the extreme end of either of the spectrum.
Thank you.
Anjali, yes, you were saying something. I'm so sorry to interrupt you.
No issues, ma'am. Actually, that was a great sort of a remark from both the professors. So my question is just slightly different, and this is not containing to Hart as such, but it is around the debate of natural law versus like legal positivists and naturalists. So and especially using Hart, I do understand that he's reiterating the fact that we can also see that there are so many judgments we have that include morality but do not make it the be all and end all of that understanding of the principle. But I want to pose a question to all the professors that isn't morality also something that is derived sort of naturally? And I may be using these words in a very reductive sense, but to an extent, like for example, let's say the anti-Semitic movement during Hitler's reign or during the Third Reich. And my question was that, I mean, even if there was something called morality, even if that did govern, even if that preceded over natural law, we can't ensure that it is always falling on the, let's say, the spectrum where justice lies. But it does lead to, like what we saw in Sabrimala, despite having such a strong sort of legal language for the entry of women, despite understanding that, to me it seems that legal language or legal principle somewhere is not speaking the language of empathy. And like similarly today, we were discussing in Professor Kamala Sanskaran's class about secession. It's very unfortunate that she's very famous and I could not get my question in. So, but I really wanted to pose this to her because the way we are being taught certain things like you could now also say that this is a very pedagogical comment or question. These are all questions actually. These are all doubts in my head. So she was teaching us secession and, we were being thrown with words like territorial integrity, bifurcation, states, unions. But my question is that, after the application of Article 370, we were not even allowed the common, what shall be perceived as the common morality or common, you can say, functionality of one of our most basic freedoms, the freedom to express, dissent, all of those. And I mean, these are very varied questions, but that was my question. And I had one more doubt. This is purely like on the theory that Hart did borrow from Bentham, and he was a utilitarian philosopher. So wasn't utilitarianism something that was not seen as a good idea? Like, I'm not clear on this, so that's why. Yeah.
Okay, I did not understand the entire question, honestly. So if the first part of your question wanted to ask that the major challenge of natural law was that, if they are taking the premise of legality on morality, then who decides whether the morality is right or wrong? Is that right?
Ma'am, I can put those for you in like just bullet points. Like I had 3 questions, so I'll just in one-liner, so it'll be clear for you to answer as well, if you'd like that.
Yeah, sure, please.
So isn't morality, that is something derived naturally, so essentially being like a sub-part of like natural selection or natural law? And the other question is a paradox of this, that if law indeed does encompass morality, like Anumeha ma'am had mentioned in one of her previous lectures, that morality is a small part of justice. So even on those bases, when we talk about things like secession, when we talk about anti-Semitism, how is that morality when we are not even offering basic empathy, basic rights of expression, right of speech? And the third was just whether wasn't utilitarianism a bad sort of an idea? Like, I think it was condoned by a lot of scholars in that era. So if we are deriving our this was my problem, because if we are deriving something from utilitarianism, wouldn't that be problematic essentially if the basic theory was problematic?
Okay, your first question about morality being derived from the natural law thing. Well, first of all, let me just reiterate one thing, that while we are discussing Hart, the Hart's philosophy, because there are a lot of other legal philosophers that we will be studying, and that's there in your course. So once we study all of them, probably it will be easier for us to answer these questions, because now when I try to explain, I don't know whether I'm making sense or not. Regarding your third question, Anjali, utilitarianism, I didn't understand how you are connecting this morality with utilitarianism, and we have not discussed it. We do have a paper here which discusses about number one. Number two, your first question that spoke about morality being derived from natural law. Yes, and as far as I can understand Hart, even Hart is not really refuting this matter, that morality is something that is something which is based on the natural system. If you remember, when Hart speaks about the truisms, those truisms are the backgrounds, the basic lines maybe, from which you derive that there are certain things which need to be, or which are imbibed into human DNA, by virtue of being born as a human being, by virtue of being by virtue of understanding them as being implemented in the daily life of a person. Definitely yes, but then what we need to understand, Anjali, and I think even Hart points that out, is this morality that we are, and this is also the greatest challenge to natural law, that while we do not refute the fact that morality is an extension of or is rather rooted in its understanding from the natural theory itself, but at the same time it is varied. And because it is varied, what the natural law philosophers did is they just say morality. Now, morality, of course, there are various thinkers in the natural law school as well who spoke differently. But overall, if we see, we talk about morality as a whole, which is, not just a part of justice according to them, but it is justice, and it has to be ensured. In order to ensure that you are just, you have to ensure that you have morality in you. The problem here is, now morality is different from different people, right? Morality also differs. My individual morality might not align with the social morality. For example, let's say the social morality is that we follow certain rituals while we do a puja. My individual morality is that I don't need to do that. It is so varied and it is so vast and it is so abstract. We need to understand here morality itself, the concept is not just volatile and huge, but it is also abstract in nature. While the natural law philosophers did speak about morality, a lot of their theories are based on these abstract understanding. Vis-a-vis, while we, instead go towards heart, or we see heart or study heart, heart is trying not, to do away with those abstract understandings, whereby you can see that this is moral, this is immoral, this is right, this is wrong. Instead of going into that debate, heart just, abruptly stops that and says that law per se is law. And then we maybe bring in morality, different forms of morality to check whether it is right or wrong. So as far as your first question is concerned, Anjali, regarding morality having its origin from the natural theory itself, which is absolutely right, it does. And that is the reason that a person like Hart, who is trying to, draw a middle ground, instead of, accepting either of the extreme points that are propagated by the natural law and the positive law schools, he tries to bring in a middle ground and says that we do imbibe both. But at the first instance, we do not imbibe morality. So at the first instance, we let law be the way law is. And then going forward, we bring in morality. This has two, important effects. The first is that while I make the law, I don't need to think about it. If something feels right, I make the law. So even if it is devoid of morality, it is fine. The second advantage is that at the second level, while the scrutinization happens, I exactly know that in this framework of law, which is already made, from which point or from which aspect I would like to, I would allow the morality to enter, and from which aspect I would restrain myself from maybe intermingling with morality. So this is what Hart says, Hart's philosophy. Regarding your third question of utilitarianism, yes, I did understand that you were speaking. These were two different separate questions. I did understand that. But I did not understand that why are you talking about utilitarianism in this context? That is something I'm yet to understand. Regarding your second question, I think Anumeha, would you like to answer that?
Could you just repeat your second question? Anjali, could you just repeat the second question?
Just a minute, ma'am. Sorry, I had some backlog because of the Wi-Fi. So my second question was actually a paradoxical sort of problem to the first one itself, which is fine. I mean, it's not really a question, but I do understand that I think when we are studying legal philosophy, to me it feels like probably like a table tennis sort of feel. Like we keep going back and forth from natural law to legal positivism. But actually my third question, I was just typing in the chat box, ma'am. I actually asked, I haven't read the philosophy of utilitarian, like I haven't read Bentham's theory, but I mean I have read parts of it, excerpts from it. So if you could, just for extra reading, if you could suggest something. And why I was asking was because isn't it devoid of morality? And if you mentioned, and I only asked that because you mentioned Bentham while answering Vikramaditya's query. So that's why I asked about it, and if it had an influence on the derivatives of like legal morality or any of that. So that was only, it was like very open-ended. Obviously, I'm yet to read on it. So I apologize if it seems a bit...
That's perfectly fine, Anjali. I think... with legal philosophy, you're right on one account that if you start picking up any issue, it becomes an endless kind of a discussion, right? So that's why the pedagogy that we need to follow, at least even when we are whether we are discussing it in the classroom or whether we are studying it we are studying it ourselves as well, is that try and invoke questions in context of the reading that has been taken up. So while when you're talking about morality, we can talk about different jurists talking about different aspects of morality, and every jurist or every author was about take or stance on morality differs. Their definition differs. I think the pedagogy. Yes,
ma'am.
Yes, Shubham.
मैम मोरालिटी की एग्जैक्ट मीनिंग क्या होगी? इनके हिसाब से वो अंजलि के हिसाब से अंजलि कुछ तो डिस्क्राइब कर रही थी.
Okay, just let me respond to Anjali, and maybe then we can take up your comment and discussion. Shubham, is that right?
Yes, ma'am.
Okay, so Anjali, what I was saying was that and maybe I'll also respond to Shubham in the mix, and before Anjali comments on Shubham's question to her, that we can't have an exact definition. Please don't look for exact definitions in law per se. Don't look for exact definition. Law is, and this is something that I often repeat in my classes, that it is not a mathematical formula that you are dealing with. Though we are trained to study every discipline because we are trained in scientific methodology, so we are trained to study every discipline, that if that 2 plus 2 is going to be equal to 4, that is not the manner you deal with law, and especially with philosophical subject. There cannot be any exact, precise definition of any word or anything, and that is why even in language, if you study, yes,
मैम बट हार्ट तो साइंस पे बात करते हैं ना?
साइंस पे कैसे बात करते हैं हार्ट, ये बताइए. And what is it that you mean by science? Because we are dealing with concepts here, Shubham. So we need to be
natural science, ma'am.
What is natural science according to you? What is according to you natural science?
Oh, ma'am, speaking of science in this context, I feel that the closest that we come to scientific method in Hart's philosophy is when he talks about the external point of view, where an alien seemingly observes the behavior of people in society, and then he models his behavior based upon that. Talking about the example relating to the red light. So I think science could come into that sphere, but then once we talk about the internal point of view, I don't think the scientific method would have much value. So
the reason why I'm asking you what you understand by scientific method, so that I can respond to what is scientific method. Now, scientific method depends on material confirmation, right? So there is a hypothesis, and that hypothesis has been tested, and on the basis of empirically collected data, that hypothesis has been concluded as proved. So these are scientific methodologies, right? If you understand scientific method and what is scientific methodology that we talk about. Now, so for example, if there is, let's take the example of any experiment that we conduct in science, every experiment conducted in science, and if we say that there is a scientific methodology, it has to have a hypothesis, it has to have certain empirical data proving that hypothesis, and then we prove that the hypothesis is true. So that is, and that may be on the basis of deduction or induction, whatever, but that is per se a scientific methodology. Now, what Shubham is right in the sense that there has been an application of scientific methodology on law. In the sense that the reason why there has been an application of scientific methodology on law, and it started with specifically Austin and Kelsen. Now, if you remember, Kelsen calls his theory of law pure theory of law. And the reason why he wanted to do that, because he wanted to isolate law from other disciplines, okay, such that when we are talking about law, you're only talking about law. You're trying to give as much objectivity to law. You are going to reduce the influence of other subjectivities or other disciplines on law as much as possible. Now, when we talk about scientific methodology of law, what we mean is that we are going to reduce the influence of other disciplines on law as much as possible, such that law is developed as an independent discipline altogether. So, please try to understand scientific methodology in the context of law in this regard. When we talk about scientific methodology on law, what we are doing is not that we are developing law as if we develop science. That is not what we are trying to do. We are trying to borrow the methods that are used in science and apply it on law. At the same time, recognizing that the precision that we demand in science is not applicable on law. That is not possible. So that's why maybe in mathematical science we can come up with the formula 2 plus 2 is equal to 4, but in law we cannot come up with such kind of formula, so we can try to apply that methodology on law. So first of all, that is something that you have to understand. Now, therefore, in furtherance of this idea, what you need to understand that law will never give you any precise answers. There cannot be any questions that will be precisely answered or precisely defined. That is not possible. What law can do is, it can give you the framework within which definitions are to be found. Now, if you remember in the last class when we were discussing Hart's paper on positivism and separation of law and moral, we discussed something called core and penumbra, right? That every word has a core meaning and then there are penumbral meanings. Now, for example, let's say something has been defined in law that will have as vehicle, and that is the example that was taken, that vehicles are not allowed in this specific area. Now, what is a vehicle is something that we need to determine. So, vehicle that itself may appear to be a very objective term, but it is actually not an objective term. There is a core meaning to the term vehicle, and then there is a penumbral meaning to the term vehicle. The core meaning of the term vehicle can be several, for example, car, cycle, and all the vehicles. But when we talk about penumbra, it is not necessary that the law is generally talking about all kinds of vehicles. It may very well not be talking about spaceships. It may not be talking about submarines. When it is talking about whether vehicles are allowed in a specific parking spot or not. Now let's take the word gay, okay? Now, if you are using the term gay in the context of, let's say, as a general word, few years back, the term gay signified being happy, and it is still used in that manner. But let's say the law uses the term gay in the context in a law that was passed for legalizing same-sex marriages, and the term gay is found in the same-sex marriage. How are you going to interpret the term gay? We are going to interpret the term gay in the context in which the law was made, right? So that is why every term, the reason why I am giving you these examples is no term can have exact precise meaning. Everything in law is contextual. It has to be understood in a specific context. And that is why there is no precise meaning to anything. What you can only gather from every jurist who talks about law or who talks about morality is that every jurist will have certain take on morality. That this is how I understand morality to be. But if you were to ask for an exact, precise definition of morality, I think it would become very difficult. Rather than doing so, what you can perhaps do is you can locate how Hart discusses morality, or how Fuller discusses morality, or let's say how St. Augustus discusses morality, or how any of the natural law school theorists discuss morality. Instead of saying that what is an exact definition of morality, that may become difficult. That's why the pedagogy or the methodology that we need to follow is that we need to confine ourselves to and when we are invoking law, morality, justice, let us confine ourselves to the context that we are discussing law, morality, and justice in. So for now, we are discussing law, morality, and justice in the context of Hart. And in that sense, if Hart had to define morality, for example, for Hart, morality and justice are not interchangeable. Now, Ruchita has dealt extensively on what Hart means by morality and what is it that Hart means by morality. But again, I don't think, at least I think no one would be able to give, Shubham give you an exact or precise answer to what is morality, something that fits everyone. That is not possible. What we can, however, try to do is try to find what Hart meant by morality or what Fuller meant by morality or anyone else meant by morality. I hope that answered your question, Shubham. And if not, please let me know. You can comment or you can disagree with what I'm saying.
Ma'am, agreed.
Okay, thank you, Shubham. Then, Anjali, would you also like to comment? Because I think Shubham's question was also partly addressed to
Ma'am, actually, I had another question to ask of you. The second question, it occurs to me that I did not pose it well.
Yeah.
So I'll just try and just explain it before asking. So to me, it appears, and even you can take that, and we are studying Hart right now. We can take it in the context of Hart or whatever theorists we are going to come. Since you have also with the previous query, you have also answered, like given us an umbrella view of the subject as well. So my question is that when discussing terms like morality, justice, legality, law, all of these terms, there appears to be a certain gaze. What in the school of anthropological law is also called as othering. So my question, when I was talking about anti-Semitism and like, for example, today's constitution class, this session, when we were talking about these terms during the class, it occurred to me that the constitution, which we are allowed to critique, absolutely, but then again, we have this adjoined like morality with the idea of questioning it, that only a certain person of certain stature is allowed to question it. Let's say a layman who does not speak the language of law, who does not speak the language of the court, you know, he's all of a sudden, you know, an imbecile, somebody who cannot question it. And when this particular person raises their objections to, let's say, the first line is that, you know, Union of India, the Bharat, unity of all states. But historically, if we look at it, like there has been trouble in the Northeast, there has been obviously the biggest example being Jammu and Kashmir. While unifying it, we have actually somehow successfully, and I'm not saying this, but a lot of scholarly people have said this. Recently, I read A.G. Noorani, but there can be others on both sides of the argumentative spectrum. But to me, it appears that when we discuss secession or when we discuss, you know, these I'm specifically going to stick to secession right now because we discussed this today, and you know, shouldn't we be allowed the idea of talking about the fact that, you know, the fiction of a nation state that is India may not be the reality for so many people.
हेलो
Yes, Shubham, you want to say something?
मैम, अंजलि कहना क्या चाहती है वो समझ में नहीं आ रहा है, थोड़ा उनको बोलिए, थोड़ा क्लियरिफाई करें.
I'll try to. I think I
Yes,
understand
ma'am.
the question.
Please go ahead. Yes, ma'am.
I think what Anjali is trying to say, and first of all, I'll just lay the background of my response, that you need to first understand the difference between law and application of law. Okay, that is one thing that you need to understand the difference between. That just because there is a law and the law is not being applied in the manner it should have been applied does not mean that the law is not legally valid. Okay, this is something that you need to understand. This is something that has been discussed both by Hart and by Kelsen. If you remember, Hart discusses the idea of efficacy of law, and Kelsen also discusses the idea of efficacy of law. Now, just because a law is not being applied in the manner you think or anyone thinks it should be applied does not take away the legal validity of that law. And if we consider it from Hart's perspective, a law is legally valid once it has been conferred the legal validity by a rule of recognition. Now, that rule of recognition need not always be a moral rule. The rule of recognition may or may not have morality. It may or may not reflect morality, right? So, yes, Mansi. So, the example that you're giving is very correct. That, for example, what she is giving, that Domestic Violence Act is a law, okay? And just because that law is not being implemented properly does not take away the legal validity of Domestic Violence Act. It is still a law, okay? non-consensual sexual intercourse within marriage is not penalized. That is the law. Marital rape is not recognized. Not just because we think that marital rape must be recognized does not mean that non-consensual sexual intercourse within the marriage today is going to be penalized by the law. Okay? That is, so law and application of law are two different things. Okay? Dowry Prohibition Act, we have a law, but Dowry Prohibition Act also is flouted more than it is applied. Okay, and you will find that individuals who have been given the power to implement dowry protection laws are themselves who engage in the taking and giving of dowry, right? So, but just because of the fact that dowry prohibition laws are not implemented,
Ma'am?
does not mean, so just give me a second and then I will come to your question.
Okay.
Just because dowry prohibition laws are not implemented does not automatically mean that Dowry Prohibition Act is not a valid piece of legislation. Now, having said that, if I understood Anjali correctly, what she was saying was that every law has certain problems attached to it. And Anjali, please correct me if I'm wrong. And law suffers from this problem of othering. Now, what is this othering? Now, othering is a concept wherein law always reflects the majority opinion, and the marginalized are often not accounted for in the law. For example, same-sex marriage is not accounted for in the law. Law has made absolutely no provision for same-sex marriage. Till very recent times, sexual harassment at workplace was not accounted for in the law because law did not recognize sexual harassment at workplace against women. Now, the reason being the reason for it was because women, people of certain sexual orientation, all of them are marginalized. Okay, all of them do not form the majority of the population. And that's why law has a tendency to reflect the opinion and the morality also in some regard of the majority of the population and not the minority of the population. Now, in that context, if you put Anjali's question, law as such, and Constitution also being a law, will always reflect the majority's opinion. It will in one way or the other marginalize and other, or there will be a phenomenon of othering of the marginalized individuals, such that it is quite possible that law penalizes marginalized for raising their voice against the authority of law. That is quite possible. Okay, Anjali, did I understand your question correctly? Was this that you were trying to ask? Okay. Now, Shubham, did you also understand the question that Anjali was posing?
मैम?
Yes, Shubham.
मैम, लॉ और एप्लीकेशन ऑफ लॉ ये दोनों एक नहीं हो सकते हैं?
हो सकते हैं, लेकिन अलग भी हो सकते हैं।
तो मैम, अब जिस हिसाब से आप बता रहे हैं उस हिसाब से तो पूरा लॉ झूठ है फिर।
हाँ, लॉ प्रॉब्लमैटिक है। झूठ कहना पता नहीं सही है कि नहीं, पर लॉ प्रॉब्लमैटिक है। आप लॉ की क्रिटिक, आप क्रिटिकल लीगल स्टडीज पढ़ेंगे तो वो तो क्रिटिकल लीगल स्टडीज
मैम, आपने बोला कि ओपिनियन पे होता है, तो ओपिनियन मतलब ज्यादा लोग की जिसके तरफ ओपिनियन में गलत भी हो तो वो तो फिर सही हो जाएगा। तो
ऐसा सर, आप ऐसा होते हुए नहीं देखते। आप अपने एक्सपीरियंस में बताइए लॉ क्या कहता है।
नहीं होता है मैम, तो इसलिए तो हम थोड़ा वो बोल रहे हैं ना, थोड़ा
हाँ जी बताइए।
परफेक्ट नहीं हो सकता है, ये कभी भी नहीं हो सकता।
If I can stop for one moment,
Please, Ruchita, please.
Just one moment. Shubham, what you are exactly saying is something that even Hart said. देखिए, हम ये डिस्कस कर रहे हैं, हमें पता है कि सोसाइटी में कुछ चीजें चलते हैं। अभी अनुमेहा was explaining that how law is different and application of law is different. लेकिन instantly, out of all the people, we all know that this happens. But you had a morality in yourself which spoke out to say that this is wrong and this cannot happen, right? But on the other hand, a person who agrees with the majority of opinion in the society, for them it is absolutely moral. this is exactly the challenge of law. And this is exactly why Anumeha was saying that law and its applications are different. So even if we have a law, it is not necessary that we can always apply it. We have a dowry prohibition law. आप बताइए कितने cases आते हैं dowry prohibition में? आप बताइए dowry होता नहीं है, gifts नहीं होते शादी में. North India में तो ज़्यादा होता है, and you men also take it very happily. You men in the sense everybody takes it. I mean both. I mean the entire society is engaged in it. हमें तो पता ही ये गलत है. ये हमारे किसी को पता है.
फिर इससे तो इक्वल राइट ऑफ इक्वलिटी फिर आई कहाँ से? फिर तो गलत है ये.
राइट ऑफ इक्वालिटी मतलब?
मैम
शुभम दोबारा बताइए राइट ऑफ इक्वालिटी मतलब? I think Kirti's example is also absolutely right. Manual scavengers, it is prohibited. But we know that they still exist. There are so many people, an entire community whose livelihood is based on that. However menial and humiliating that is, we all, है ना?
अगर हमें पता ही है कि मतलब कि दो ओपिनियन अलग अलग हैं, अगर कोई इक्वलिटी के लिए करता है तो उसको इक्वलिटी कहाँ से मिलेगी फिर?
मैम जस्ट शुभम के ही मतलब मैं अगर हिंदी में बोलूंगी तो जो शुभम कह रहे हैं कि इतना सब कुछ पढ़ने के बाद इतना थ्योरी एप्लीकेशन प्रैक्टिस लॉजिकल रीजनिंग के भी बाद सोसाइटी हमें भी पता है कि परफेक्ट नहीं है, बट वो जो एप्लीकेबिलिटी होती है लॉ की तो स्पेशली जब हम थ्योरी पढ़ रहे हैं तो इफ इट फेड्स अवे then it is really a sort of for the lack of a better word like an existential problem, isn't it? मतलब जो शुभम कह रहे हैं कि अगर सब कुछ परफेक्ट नहीं है तो फिर एप्लीकेबिलिटी तो वैसे भी मोस्ट लॉज की मार्ड होती है वैसे भी.
Ruchita, were you saying something?
No. Anumeha, you can say.
I think human existence is imperfect, right? So human existence itself is imperfect. So let us not understand law as signifying that law has to be perfect. So don't try to seek that perfection in law. Try to critique the law. That is how you need to approach the law. Don't try and define law. Try and define law. Try and critique law. And that goes true for all structures, all institutions. Don't try and define those institutions or structures. Try and critique those institutions and structures. Try and find the loopholes and the problems in those structures. What Shubham is saying and what you are feeling is absolutely true, and that's the dilemma that all of us face as law students. That if the application of law is so problematic, if what the law says and what the law does have so much gap, then what is the point of even having a law? I think that is what Shubham is trying to say. What is the point of having right to equality if the text of Article 14 does not enable us to ensure an egalitarian society? Now that is always going to be the case. There is always going to be a gap between what we aspire to be and what we are indeed. There is always going to be a gap. So that's why don't try and read. So what I can suggest, and that is a dilemma that all of us are going to face. I don't think I, Ruchita or Haris or any one of us can answer that concern of yours. What we can only do is provide you with the tools to critique it. That's the only thing we can do. So the reason why we are studying these theories and these concepts are so that we have the tools to critique the existing structures and institutions. Not necessarily, and perhaps make it a little bit better than what it was yesterday. But I don't think we can find a perfect definition of any of these things, because they are very subjective in application. I think Rakesh, I could not respond to the comments made by Rakesh and Anjali with regard to utilitarianism, but Rakesh, he said something that even science is subjective, right? And even law is subjective, and everything changes with circumstances. So let us I would not. The manner in which I have dealt with this dilemma is by stop looking at law or trying to find a perfect answer to what law should be. Rather, I have tried to, it is better to use the tools at our disposal to critique the law and expose the fallacies of law. That is something that we may aim to do. So that is the only response that I can think of to your question, Shubham and Anjali. And just going back by what Rakesh and Anjali they were having a discussion on utilitarianism, it seems yes, Rakesh is right in the sense that utilitarianism itself has different variants, and Benson's utilitarianism was criticized by Mill, and that is how the utilitarian philosophy in itself underwent a lot of change. But as Ruchita said, we will be discussing utilitarianism. There is an entire paper on legal utilitarianism, and maybe we can raise these questions in that class. Because once you have an understanding of utilitarianism, it would be much better to discuss all these questions. So reserve these questions, and we will again take up these questions in those classes. Rakesh is saying something. Bill built the superstructure theory on the footings of Bentham. Yes, Rakesh, you are right. That Marx built his theory of dialectical materialism on Hegel's idea. That is completely true. Ruchita, would you like to say anything?
Ma'am, I just wanted to add one point to Shubham's question. It's not just about the terms of law, because every subject is like, for example, if you take philosophy or any other subjects, it is very difficult to define and understand. So every person understands in different perception. It changes with time with respect to space. For example, a term which was used, let us say a term called Aryan, during the time of its induction, it was used in a different manner. And the concept, what we understand today, is a different manner. So it's all subjective. There is nothing like truth or untruth. It's all like what we understand. That's it.
Yeah, actually, thank you, Rakesh, for pointing that out. Borrowing from Indian philosophy, there are multiple truths. There is no ultimate truth, right? That is what Indian philosophy tells us, that there are multiple truths. There is no ultimate truth. And that is what we need to understand, the plurality and the subjectivity of human existence. We have been trained in this idea of having a cohesive, structured, one way of a human existing, but that is not truth. That is not a possibility. You have to understand, and you have to approach every institution or structure from this perspective, or the possibility that it can assume different forms. So yes, Rakesh, thank you for that comment.
Thank you, ma'am.
Ma'am, I have a question.
Yes, Shahbaz.
Ma'am, you have mentioned that laws should be understood according to the context, according to the context of when it was framed.
Shahbaz, I was basically not exactly that. What I was saying was that because we are dealing with legal philosophy, and as we have experienced, legal philosophy discussion are endless. What we can maybe try to do is try to contextualize the terms that we are invoking in the context of the discussion that we are having. And yes, law should also be understood in the context in which we are framed. Yes, in a manner, because generally when we interpret any law, it has to be understood in a specific context. Yes, Shahbaz. So sorry, please proceed with your question.
So can we justify the laws which were framed in the past, and now maybe they were considered as illegal and immoral, but maybe we can justify laws which were framed during that time?
The laws were there, Shahbaz, because they were justified at that specific time. Now, there is a possibility that a law which was justifiable or legitimate 50 years back is no longer justifiable and legitimate today. So, but I will try to maybe reframe your question, and I hope I understood what you were trying to say correctly. That whether law that was made in the context of a morality of morality that was prevailing 100 years back, whether that law would be justifiable, and if I replace the word justifiable with legally valid 100 years hence. Now let's take the example of adultery. Adultery had been the law for a very long period of time, right? Maybe it was justifiable at that specific time. But eventually we found that adultery, because of different changes in the society and the context in which and the social context in which we understood adultery, the law on adultery also underwent a change such that adultery was declared to be unconstitutional recently. So today, if you look at adultery, obviously adultery is not legally valid today, but 100 years back it was legally valid. Now, if you were to say whether adultery 100 years back was morally justifiable. Maybe it was, or maybe it was not morally justifiable. But what does Hart say? That just because there is a law does not necessarily mean that is a morally justifiable piece of legislation. That is what Hart says. Morally relevant, but not morally conclusive. Please keep that in your mind. A very powerful statement. That law is morally relevant, but not morally conclusive. And if I've understood your question correctly, Shahbaz, that adultery may be legal at any point of time. And it may be morally relevant or it may be morally conclusive. It depends. It may be morally relevant or morally irrelevant. But that is not the question that law has to answer. Law does not have to address the concerns of morality at all specific times. Morality is not something that gives legal validity to a law. It does not give legal validity to a law. That's why we had adultery for a very long period of time, despite the fact that it might have been considered to be morally wrong. But it was a legal piece of legislation. People were prosecuted under adultery laws. People were prosecuted under Section 377, even if it was morally reprehensible. So just because 377 was a law does not automatically amount to us saying that 377 is morally conclusive. That is not the case. It was a law, but it was not moral. It may or may not be moral or immoral. So that is what you need to understand, that laws that were made or enacted hundreds of years back or years back may still be laws today, provided they have not been denied the legal validity according to Hart by invoking those rules of recognition, or they have not been changed by rules of change. So a morally reprehensible law can still have or retain legally validation in today's time. So Section 377, for example, before Natya Singh Johar case, even if we consider it to be a morally reprehensible law, it was still a legally valid law before Natya Singh Johar case. Okay, so now, a morally reprehensible law can survive ages if it is not changed. Now, because it was changed, today you may say that perhaps that law reflects the morality, or perhaps law does not reflect the morality, whichever side of the moral discourse you are on with regard to same-sex relationships. But if I understood your question correctly, Shabazz, legal validity of law and morality of law are two different things that you need to understand. Just because there is something called law does not necessarily mean that all the laws are morally conclusive. It is not necessary. I hope that was your question, Shahbaz, and I understood your question.
Yes, ma'am, that was precisely my question. And can you repeat the statement which you said regarding morally relevant?
Yes, yesterday, I think Ruchita in her discussion emphasized on that statement several times also, that law is morally relevant, not morally conclusive. Now, what we mean by morally relevant is that morality does influence law at different points. Morality and law intersect at different points. So, for example, as Ruchita herself was saying, during the process of formulation of legislation, during the process of modification of legislation, during the process of changes in legislation, subsequent amending the legislation, morality may influence the making of law. But to say that law and morality are one and the same thing is not true. So that's why, because morality influences the process of formation of law at some point, it enters into the formulation of law at some point. Therefore, law is morally relevant. But law and morality are not one and the same thing. Therefore, law is not morally conclusive. Unlike natural law philosophers or something that we discussed, and those who are on the extreme spectrum of natural law thinkers, who say that what is unjust is not a law, what is immoral is not a law. So that is not something which Hart recognizes. What Hart says is that without saying that morality does not play a role in the formation of law, he acknowledges that, but says that law and moral need not always be interchangeably used. They are not one and the same thing. There are points of divergence between law and moral, such that something which is morally reprehensible can still be a law, and something which is a law may still be morally reprehensible. So that is what he's saying. Morally relevant but not conclusive.
Yeah, thank you, ma'am.
Ruchita, would you like to add anything?
No, No. It's fine. I think you have very comprehensively covered almost everything.
Any other questions that you may have for us? Otherwise, we can conclude the class for today. Should we conclude, Rachita?
Yeah, I think we can conclude then. Thank you so much, students. Yes.
We should also let them know about next week's discussion.
Yeah. So next week we are going to start with the Fuller's article, Fuller's Fidelity to Law. One thing that I think all the three of us, Srinamya, Harris and myself, would like to request you is, it will be good if you can at least, if not the entire article, but at least go through the readings once, because then it's easier for us to communicate with you as well. And like today's discussion session we had, really enriching. I'm sure Numeha would also second my opinion. We really would appreciate and love you to come forward and ask questions. But yes, at the same time, it would be good if, in a classroom setup like this, where there are a number of challenges even we are facing, it would be good if we could, concentrate on the philosopher or the article that we are talking about. So probably then it would be good. And once we are done with a majority part of our readings, maybe we can then have a holistic kind of a discussion which would help us to enrich our understanding from different perspectives. But currently, sometimes I think all the three of us would say it becomes a little bit difficult for us to address all your questions in totality, because we know that we have not discussed every part of it. So this is one thing that I would like to point out to the students, that a basic reading, I understand, the texts, like the stars reading was still easy, but the fullest reading that we are going to do the next week, it is a difficult reading. So while we don't expect you to, completely understand and read and, be well versed with it, but, a simple understanding or some of the portions of it at least would be, very encouraging for us as well.
I completely second Ruchita, and I think even Harris, he could not come today because of some specific reason, but yes, I think all of us have agreed that maybe you need to read and come. That is a minimum expectation. Otherwise, legal philosophy class will become very difficult, because even if I don't read and come to one of the lectures, it becomes very difficult for me to understand it. So I am unable to understand, and I'm sure all of us face the same problem. So even if we have read those texts previously, but if we don't read it and come before the class, it becomes a little problematic for us to comprehend. So yes, again, so maybe if you could read at least give one reading to the text, it would be helpful.
Ma'am, could you specify the reading once again?
Yeah. It's last week, what we found is you wanted some time reserved for discussing it and maybe commenting on the paper that we are reading in the class. So we have reserved today's class for that specific purpose. So please let us know if you have any questions or comments or queries. Yes, would anyone like to respond to our discussions which we had this week?
I think any questions yes,
Ma'am, I went back and read William Starr's article, and in one of the cases, he said that Hart rejects necessary correction of law and morality because, firstly, because of the issue of practicality, that we can't have a narrow approach, and secondly, he criticizes this correction based on morality itself, that if the wicked justify the laws on the premise that since it's a law and law must necessarily follow morality, then that will be the definitive answer to the question of morality. So that is a point I'm a little uncertain on. So if we could talk about that.
दोस्तों, ब्रास ग्रुप आशा करता है कि आप सभी लोगों को ये लेसन पसंद आया होगा। आप अपना फीडबैक कमेंट बॉक्स में देना न भूलें।